I mean, it's just watching it and hearing the tone in his voice, and then he goes on to play a baseball video game. It's bizarre putting it lightly, and then it's every word that you said beyond that. If he was to make an argument like I was the victim of bullying, and bullying is a big deal. I mean, it's an issue in a lot of places. I mean, I guess what weight could that carry? I'm just trying to think of,
Yeah.
because if it seems like there's so much evidence against him, and there's a long way to go in this, it just seems like how can you show up in court and then try to argue it out? If you went on YouTube, you show you had an issue with her. If you were behind the car, you did it. It just seems like it'd be a really tough case for the defense.
Yeah, so let's explore one other defense. Let's I don't know where he's going to go with it, but let's assume he's using this bullying defense. I don't know. I'm going to play like what lawyers do. Okay, let's play the game. What lawyers do. So as a prosecutor, I am anticipating what the defense is going to be. One of the potential defenses that I, in my creative mind, is going to come up with is that he was bullied by these two young girls, and he was bullied to the point where a reasonable person. I'm going to talk about passion provocation law here, where a reasonable person would have been provoked, that he in fact was provoked, that he had no time to cool off or actually collect his thoughts and to think properly. And he went out and he purposefully committed this act. He purposefully did this. Under those circumstances, if you can prove that his actions were reasonable, that the jury believes that a reasonable person would have been provoked, that in fact he was provoked, and that he was acting without the opportunity to cool off in the heat of the moment, as some put it in some venues, then he would be entitled to a passion provocation charge before the jury, maybe an area I go. And what that means in real world talk is that it reduces the charge from a murder to a manslaughter. It takes out that mental element of purposeful and knowing because you didn't have the opportunity to deliberate. You didn't have the opportunity because you were suffering under the passion of an excitable event that a reasonable person would have been provoked. What's the standard that we always use as an example? Somebody finds their wife or their husband in a bed with somebody else and they've got a gun and they don't think and they shoot and they kill that person. That would be a passion provocation defense. Do I think that would hold true here in a case where a guy gets into a car, finds these two girls, drives the car and strikes them and hits them, that the jury's going to find that that was a reasonable provocation, being bullied, that he was provoked, and that he didn't have the opportunity to think and deliberate prior to committing the act? I think it's a stretch, but it's a possible defense. Sometimes as a defense lawyer, last point, you got to dance with the one you brought. Got to dance with the one you brought. I don't know. People don't go to dances anymore. But what that essentially means is if this is the defendant you got, you throw every defense against the wall, hope something sticks. And then, of course, always the plea bargaining process, trying to convince prosecutors to plead the case out before it goes to trial.